Thank you.
And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the March 29th, 2021 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman, sitting today with Justice Sukyoung Shin and Justice Sabita Singh. We will call our first case on for today, docket number 2019 P0072, Commonwealth versus Graham. We will hear first from counsel for the appellant, Attorney Peterson.
Good morning, Your Honors. May it please the court. My name is Jennifer Peterson, and I'm here today on behalf of Mr. Eugene Graham. As Your Honors are aware, this case involves Mr. Graham being on trial for several life felonies. And here he argues in his appeal that there was a substantial question of possible doubt regarding his competence. Specifically, he was falling asleep at defense table. This is a case where Mr. Graham is arguing that once that issue was raised and once the trial judge became aware that there was an issue of competence, he had a duty to conduct a meaningful probe of Mr. Graham's mind, the same as he would as the same standard that's applied to the change of plea hearing. So, and the judge's failure here to look into, to conduct some kind of voir dire or inquiry regarding Mr. Graham's competence when he became aware was an abuse of discretion. Here, the judge seems to imply that wakefulness is a standard of a measure of competence. And we would argue that wakefulness on Mr. Graham's part is not a measure of competence, that he was required and had a duty to conduct some sort of evaluation. That first, on day 3, the judge acknowledges, after counsel says that he's been on medications that have been prescription medications provided to him at the jail before he comes to court in the morning, that those cause him drowsiness and sleepiness. The judge acknowledges that he's noticed Mr. Graham dozing off, that he's noticed he's closed his eyes from time to time, and his solution is that he would wake him up. And several times throughout the trial, there's behavior. Once it's sidebar, he actually references the fact that, you know, he's doing this to wake Mr. Graham up.
But didn't the judge, I'm sorry, but there are indications in the record, aren't there, that the judge did more than assure that your client was awake? For example, this is volume 5, page 37. During a sidebar, the judge said, obviously, I'm making sure that the defendant is awake and paying attention. And the judge made other comments during trial of a similar ilk. So I guess my question is, how on this record can we agree with your determination?
Well, I would suggest, Your Honor, that the judge here is not an expert, and I don't think the judge, like I said, competency, wakefulness is not a measure of competency. And even the fact that it appears to the judge that Mr. Graham is awake,
and paying attention.
But he doesn't know what the impact of the various drugs that Mr. Graham is taking, what they have on his ability. That's just the judge's perception of what he believes, you know, Mr. Graham's level of awareness is. That doesn't say anything to his competency. We can look at people who are mentally ill and they can appear competent, but that doesn't really have any relevance to their actual ability to perceive or understand anything.
So anytime a judge is aware that somebody is on medications, it's incumbent on the judge to make an inquiry as to what those medications are, what the effect of those medications are?
I would suggest that similar to a change of plea hearing, and that's what the Russing case says, that the obligation is similar to that, the judge should ask the defendant, are the medications that you're on, do they affect your ability to understand what's happening here in the courtroom? Not just do you appear to be awake, do you appear to be understanding things, but are you actually able to comprehend what's taking place? And I would suggest that—
Did his trial counsel, sorry for interrupting you, but did trial counsel make any such allegations?
Trial counsel did not. However, I would suggest that that is not what the case law says. The case law specifically says that it's not a question about, in Hill, the 78 case, 375 Mass, it specifically says that if there are elements of an indication, that it's the judge's obligation.
But what were the indications in this case? The indications were that he was on medication, he was sleepy. Does that, many medications may affect, may have the effect of drowsiness. For example, allergy medicines.
Yes.
Right?
Yes.
But from that, a judge is, you're saying that would be an indication of competency, a competency issue that a judge must undertake sua sponte?
I would suggest that a judge has a duty at that juncture to at least hold a voir dire and inquire if the judge becomes aware that if there's some sort of indication in the courtroom at the time of trial that there is a question regarding the use of drugs or alcohol, or there's some question that would call into question a defendant's competency, the judge has an obligation.
But that's where it's a bit circular. You're saying some indication that calls into question competency, and drowsiness due to medication. I'm not sure that you can say that calls into question a person's competency. And you're saying defense counsel has no obligation under the circumstances?
I think defense counsel did raise the issue here in front of the judge and specifically said that that her client was having problems staying awake, that he was having problems specifically as a result of the fact that he was administered medications prior to coming to court. And I'm saying at that point, it triggers for the judge an obligation, at the very least, to hold a voir dire and speak with Mr. Graham about whether or not these medications that he's been administered, if he has a mental illness, because there was significant suggestions throughout the transcript that Mr. Graham suffered from a mental illness. And there were also suggestions that he had taken medication. So those particular things should have been enough to trigger the judge to at least hold a voir dire and inquire further. So the issue was raised by counsel. It was just not followed up with, except for the fact that I will wake him if I see him asleep. And the judge acknowledged, even from on day 3 of a 9-day trial, that in the past, during impanelment, that he had seen Mr. Graham nodding off. So this was a persistent problem. This just wasn't a transient problem.
In a number of the cases analyzing this type of issue, we see it done in the context of a motion for new trial so that a record can be more fully developed. We don't have one here. I saw from the docket that that's something that was contemplated but not brought. Can you tell us why?
My client chose not to go forward and that was my client's decision through a motion for new trial. He preferred to go forward through a direct appeal. So
the request made by trial counsel when she brought up the issue initially was that the defendant be allowed, if he is feeling drowsy, to get the attention of the court officer and take a break. And that was the accommodation that was requested. So given that, why would the judge have to conduct a voir dire at that point? I mean, it seems like he was very attentive and accommodated the request, and there was never any other issue raised by the defendant later at trial that he needed a break.
I think the case law is clear, Your Honor, that it becomes it's the obligation of the court to ensure that the defendant is competent to stand trial. And while ideally trial counsel, as part of that, trial counsel did bring the issue of his difficulty staying awake to the court's attention. And I would suggest that at that juncture, once the judge saw it himself, and once the judge was aware that Mr. Graham was on medications, that it was the judge's obligation to inquire what type of medications, how are they affecting you? Did you miss part of the trial? Even if he had been found, even when a juror is found sleeping, judges frequently bring them up for a voir dire. What did you miss? What's the last thing you heard? They inquire just to ensure, to satisfy the record, if nothing else, that there isn't a problem. The judge didn't even bring Mr. Graham up for a voir dire regarding whether or not he had missed chunks of his trial, whether he was, what the medications were doing to him. Everyone in the courtroom, the judge, the counsel, just seemed to believe that provided that Mr. Graham was awake, he was receiving a fair trial. That was the standard for competency, is wakefulness. And I would suggest that's simply not enough. And in fact, that, in that Hillset case, they said if there's elements that proper notice has been taken of them, if there's a substantial question of possible doubt as to the defendant's competency to stand trial, it's the judge's duty to inquire further here. It's the judge's duty to inquire further. And the bar is low. And the Corbett case that's cited by the Commonwealth in its brief specifically says that the appeals court in its decision said that it didn't have the occasion to assess the meaning of that standard when the judge is required to order a competency evaluation. But the Corbett case, the Corbett panel said that the bar is very low. So I think the issue of competence is one that's ongoing, and the courts, different cases refer to it as a fluid standard. And here, I would argue, Mr. Graham does argue, that it's the judge's obligation here to ensure that we're not just looking at the symptoms of possible symptoms of competency, which would be the sleepfulness, but actually do some kind of inquiry as to how it's affecting him, not how it's perceived by outsiders, which is the sleepfulness, but how it's actually affecting Mr. Graham and his ability. And the only way to do that would be to conduct some sort of colloquy, which, and as I said before, the Roosing case specifically says it's the same standard. So I would suggest that a judge would not take a change of plea in similar circumstances. They would say, have you taken any medication or any alcohol today? And if a defendant said yes, that would trigger a further question. Does that medication, does that alcohol, does that whatever, do you have a mental illness? Does that affect your ability to understand and perceive what's going on and to make this plea? And that's the same standard that should be at trial. The judge should ask whether or not these drugs affected Mr. Graham's ability to participate in his own trial for life felonies and to be able to stay awake and to stay aware of what was happening. And he very well may have said yes, he may have said no. We don't know what he said, but there's nothing on the record. And the judge had an opportunity at that juncture. There were several opportunities at the junction, at this trial, whether it was when defense counsel told him that Mr. Graham was taking medications, whether a number of the witnesses said he was mentally ill, he was taking medications for the illness, and he himself, when he took the stand, said that he was taking he took medications for his mental illness. And at no juncture in this 9-day trial did the judge inquire, despite the fact there were, and they're cited in the brief, things like, after the mother testified, the complainant was about to come and testify, which would be a significant event. And the judge, right after a recess, just up and goes, you know what? you know, the prosecutor tried to call the complainant to the stand, and the judge says, you know what, no, I forgot to finish my coffee, and he leaves the bench and they take another recess. I mean, that type of behavior also, see, I would suggest that even if the jurors didn't notice that Mr. Graham was dozing off and falling asleep, they could certainly must have had some sort of awareness that this behavior on the part of the judge was a bit strange. The judges don't leave the bench to have more coffee, you know, right after they return from a recess. I would suggest then, with respect to, I haven't had a chance to check to discuss my second argument, but with respect to that argument, I would rest on my brief. Thank you, Your Honors.
Checking to see if there are any further questions, and seeing none. Thank you, Attorney Peterson. And we will now hear from counsel for the appellee, Attorney Moriarty.
Good morning. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honors, the trial judge acted within his discretion in proceeding with the trial without sua sponte ordering a competency evaluation, where there was no indication that the defendant could not remain awake and alert. The judge had no information had no information generally other than from the defense counsel that the defendant had any sort of competency issue, where he was not otherwise informed, and other than the simple fact that he was taking medications and that were making him drowsy. The rule that defense counsel argues for today would require basically this kind of colloquy at the outset of almost any trial. I think it's fair to say that many defendants are on medication. And so if it's simply the fact that a person is on medication that requires a colloquy, then the defendant is suggesting that on almost every trial, this colloquy needs to happen. But here, this doesn't even approach the quite low threshold that's required for a judge to order an evaluation. When informed by the defense attorney that the defendant was on some medication that was making him drowsy, the judge explicitly found that the defendant was, quote unquote, paying close attention to the impanelment. And then although the defendant closed his eyes from time to time, he, quote unquote, immediately opened them. Moreover, the judge acknowledged his continuing obligation to ensure that the defendant was awake, alert, and an active participant in his defense. Numerous times, the Commonwealth cited in its brief, the judge noted explicitly that he was paying close attention to the trial. He interrupted the parties so that so that everyone could hear the witness. He observed the conduct of the spectators in the back. It's important to note that defense counsel, who had the most intimate interaction with the defendant, never requested a break for her client. And I think one thing that the case law also discusses is that in evaluating whether Judge Liu abused his discretion in not ordering this evaluation, we can consider the defendant's own testimony. And here the defendant testified in his defense. He was coherent, logical, responsive to questions from both the prosecutor, from both defense counsel and the prosecutor. And so I would simply say that based on the limited information from defense counsel and the judge's own observations, it was not an abuse of discretion to proceed with the trial without ordering a competency evaluation. If there are no further questions on that point, just briefly turning to the alleged errors in the prosecutor's closing argument.
Well, let me stop you right there. You say alleged errors. At one time, and I'll read this to provide context, at one point the prosecutor argued, quote, "People do not want to believe that there are people in the world that hurt children, that really happens, but the defendant does not get the benefit, excuse me, of that prejudice." How is that not error, opposed to alleged error?
Your Honor, I think it's a bad choice of words. I think as a lawyer, she probably used some words that she shouldn't have used. I think the gist of that argument was that people don't want to believe that bad things happen. Yet you, based on the testimony you viewed in this courtroom, you can find that a terrible thing did in fact happen to this child.
How is it relevant? I mean, how is that a summary of the evidence or an argument as to what to believe? That people, how is speaking in generalities about good prejudice versus bad prejudice in any way appropriate closing argument?
I see Your Honor's point. I do think that it's that generally speaking to common experience is fair in a prosecutor's closing argument. And I think that the general experience is that most people don't experience this kind of abuse in their life. I will concede that.
Yeah. So I have trouble with what you're saying right now. So is the gist that the prosecutor is saying, hey, these things happen, so you should believe that it happened here?
I don't think that she's saying that it was an improper comment, Your Honor. I
agree.
I think it's fair to say that it was an improper comment. However, there was no objection. And I think that really goes to the nature of the comment, the fleeting nature of the gist of her argument. And so despite the court's finding that it was an improper comment, there was no substantial risk of a miscarriage of justice in this case. I think these kinds of cases are difficult to argue. The case law is replete with evidence that it's difficult to draw the line between improper appeals to juror emotions in child sexual assault cases. This crossed the line. But repeated instructions over the course of the trial informing the jury that the defendant was presumed innocent until proven guilty, both during impanelment, prior to trial, and at least during closing arguments. I cited at least 4 occasions in my brief, and the case law that states that the jurors are presumed to follow the instructions ameliorated any potential prejudice. And I will, and perhaps most importantly in this case, the defendant was acquitted of the most serious charges of aggravated rape of a child across the board. He was found guilty of the lesser included offenses. So I think you can fairly be confident that despite any missteps by the prosecutor in her closing argument, the jury was not swayed by any improper appeal to prejudice.
But you could make the opposite argument. I know that typically when you have a conviction on a lesser included rather than the higher charge, that argument is made that perhaps the jury wasn't swayed by the appeals. But the opposite argument could be made that it was a much closer case because they're not really looking at those higher charges. They're looking at indecent A and B, and these appeals, what it could have made all the difference.
I think, again, given the fact that it was not objected to during trial, given the substantial risk standard here, and where the one charge that was charged as an indecent assault and battery was returned as an indecent assault and battery, I think that all goes to show that the jurors credited the victim's testimony. Generally, wholesale credited the victim's testimony, credited the first complaint testimony, but they, however, had difficulty with the penetration element, and so therefore they returned indecent assault and battery convictions.
But all of the arguments regarding the issues with the prosecutor's closing really go to that credibility assessment. Could you address the argument that how would this victim have this sexual knowledge except if this actually happened?
Sure. The case law is fairly explicit that there needs to be an absence of other potential sources of information where the child could have gained age inappropriate sexual understanding of sexual intercourse. Here, there was testimony that the child had no access to internet. She was 4 and 5 years old. She had no siblings. She lived with her mother, the mother's boyfriend at times, and the defendant. There was no evidence either at trial or prior to trial that the defendant or that the victim was ever allegedly abused by anyone else. There's no evidence either at trial or in any other part of the record that suggests that the defendant had, or that the victim had, was in contact with any other children that had been abused. And so again, I think the court reviews the statements made in closing argument in context of the whole argument, in context of the evidence admitted into trial, and in with respect and with the background of the judge's closing, with the judge's instructions to the jury. And I understand that these two statements may be, one, definitely problematic, and then the argument about whether the child had any other source of how she would have known about what happened might be somewhat problematic. But and again, I'd just like to point out, I'm sorry, that with respect to the fact that how else would the little girl have known about the mechanics of sexual intercourse? This was in direct response to the defendant's argument that the victim shouldn't be credited because she didn't say it hurt. And so I think that when you view the evidence cumulatively, when you view the prosecutor's closing argument in light of the evidence, in light of the jury instructions, and in light of the arguments that the defense attorney made as part of his closing argument, any errors simply don't rise to a substantial risk of a miscarriage of justice.
So the argument about the fighting between the mother and the defendant and threatening to kick them out, is there any evidence that the child was there when the fighting was going on, or that she knew about it in any way?
To directly answer your question, no. I don't think there's any direct evidence that the child was present during any of those arguments.
So how is it a reasonable inference that could be a reason why for the delayed disclosure?
I think it's reasonable that the arguments between the victim's mother and the defendant would have occurred in the apartment that they shared, and that the victim would have been with her mother at all times when she was not in school.
She was very young, and the expert testimony was that this kind of issue would affect an older child. And I don't think it's reasonable to say that this victim qualified as an older child, right?
No, I think older children would be 8, 9, 10 years old. I think, again, this argument is meant to rebut the defendant's argument in his closing that said that this was fabricated by the child to get the defendant out of the house so that the victim's mom's boyfriend could move in. These arguments aren't in a vacuum. They're directly responsive to the defendant's arguments that this victim can't be credited, that this little 5-year-old child created this big lie in order to have her mother able to get a restraining order against the defendant, to get the defendant out of her house so that the person that she referred to as her stepdad could move in. So I just point out to the court that these arguments are really in direct rebuttal to the defendant's claims that this child victim should not be credited. And if the panel has no further arguments, the Commonwealth will rest on its brief.
Seeing no further questions, the case is submitted. And I want to thank, on behalf of the panel, both counsel for your helpful briefing and argument.